Hello, happy Friday. Welcome to Happy Hour on the Your Strata Property Facebook page. It is fabulous to be here. We are in our we've completed our second month of running Happy Hour, 4 o'clock on Fridays, bringing you some virtual socializing during our isolation, during our lockdown. I am looking forward to seeing you all today, chatting with you, learning about how your week in Strata has been, and sharing with you some insights, some events that have been happening around the country when it comes to our apartment buildings, and of course, welcoming in our very special guest today. And you will be able to see from the title to this video that our special guest is indeed the fabulous Dr. Nicole Johnston. Looking forward to welcoming her in very, very soon. But for now, I would like to welcome you in. I'd like to know who is joining us today. Who do we have? We have some regulars now. I'm hoping to see you. Please pop a hello into the comments. Give me a thumbs up. Let me know that I am coming through loud and clear this Friday. Let me know what you have brought to Happy Hour. Yes, it is called Happy Hour for a reason. Virtual drinks or real drinks, whatever works for you. Today I have some bubbles. Very interested to know what you might be enjoying today. It doesn't have to be alcohol. It can be a coffee. It can be an OJ, whatever it is that you are into. Have you had a full-on week? Have you been very busy? Strata managers out there, lots going on, lots to be learning this week. We have certainly had some action out of our New South Wales tribunal, some very important decisions coming through there in relation to pets, the keeping of pets in our New South Wales strata schemes. I am definitely going to be talking about that. I know a number of you are here to hear all about that. If you don't mind, I'm just going to adjust my lights as I go here. We have some unusual weather in Sydney. I can't keep up with it. I don't know if it's going to be light, if it's going to be dark, what's going to be going on. So we just do our best. And if you can hear me, that is a bonus. Now, I know many of you can because I'm seeing those comments come on through. Hello, Michelle, who is in Glebe. Hello, Lynn and Leonard. Great to see you here. Henry, good afternoon to you. Edward, hello. Robert is here. Nathan, Richard is here from Double Bay. Drink up. We are neighbours, Richard. Indeed. I would love to know what you're drinking today. Stephen, good to be here. Great to be online with you and your community of experts. There you go. And I have once again remembered to press the button and bring those lovely comments up on the screen. So that is awesome. Hello to Sean B. He is here. Excellent. Okay, so I am, as I like to do before I welcome in our special guest, going to give you my short summary of the need to know, what I think you need to know that has been going on around the country in strata this week. And yes, as I said, some very important decisions out of our New South Wales Tribunal, the appeal panel when it comes to pets, the keeping of pets in our strata schemes. And not just about pets, right? These are decisions that tell us how we can determine whether a bylaw is harsh, unconscionable, or oppressive. So really important. And I'm going to teach you a little bit because I'm going to come back to this. I am going to be diving deep into the few pet cases and having a bit of a discussion with our special guest. I'd like Dr. Johnston to join in on that discussion. So I'm going to save it for when we bring her on. So stay tuned. One thing that I do want to let you know straight up is that I have secured a podcast interview with David Edwards of DEA Lawyers. Now, David is the lawyer who acted for the Owners Corporation in the Cooper appeal. So he is the lawyer who acted for the successful party in that appeal. There may be some champagne for David today or this week. I understand it was a hard-fought case. And I've invited David onto the podcast to talk us through the legal issues, the outcome, what it means for our strata schemes in New South Wales. There are a few additional issues still to be decided in that case. So David will do his best legally to make sure we get the need to know information. I'll be chatting to David next week and I'm going to push forward that episode so we can get it out to you for publication probably the week after. So I'm really looking forward to that and I'm grateful to David for sharing his time with me. As I said, if you're just coming in, I am going to talk about the cases. I am going to do that in a little bit. I'm going to welcome in our special guest and make sure that she can be a part of that chat as well. So stay tuned. We're coming back to those pet cases. What's happened in Queensland? A couple of things. In Queensland, their new legislation commenced on the 25th of May. We talked, I think it was last week, about the bill that was before Parliament, and this is COVID emergency response legislation. Rochelle will pop the link to that one in the comments there for you if you want to check it out. So this has now started on the 25th of May, and this legislation inserts some new sections into the Body Corporate and Community Management Act. And it allows your body corporates up there to do a number of things, to extend the due date for contributions that may have already been levied. If a particular owner is under financial hardship, then the body corporate can now make that decision to extend due dates. Lot owners will not incur penalties for late payments of contributions. So that is now in your Body Corporate and Community Management Act in Queensland, where your body corporate would otherwise be forced to commence proceedings for outstanding contributions under your legislation. In Queensland, I understand you don't have a choice about that. You have to commence proceedings to recover contributions. You now do not have to. You are not required to commence those proceedings. Now, all of this legislation is limited in time. I haven't got in my notes here what that is, but I would say it's about 6 months, and maybe some Queensland smarty pantsers can let me know if that is correct. But definitely go and read that legislation if you are a Queensland owner, committee member, manager. Important to be across. Also in that legislation, a body corporate can exceed the prescribed borrowing limit. You have some caps on borrowing in Queensland, so that legislation has addressed that issue. So really interesting for us in New South Wales to see what's happening in Queensland with this new legislation. We do in New South Wales have now a section in our Strata Schemes Management Act that allows our legislature to make regulations dealing with similar issues in New South Wales, and we wait to see what those regulations may say. And as always, this is a great place to update each other. If anyone's got updates on what's happening around the country in their state when it comes to these COVID updates, what's happening with COVID emergency regulations, then do give us a note there in the comments so that we can be on top of it. I am seeing a number of you, many more coming on through. It is good to see you. I'm jumping back over to my comments here to say hi. Thank you, Rochelle, for that kind reminder. And here we go. I am putting Michelle's comment up here. Good afternoon. Today's drinks menu is Canberra Distillery Summer Gin with Fever Tree Tonic Water. Here we go. What do I get? Just cash for comment? Can I get a little something for all that? Excellent. Good to hear. Robin is here from Canberra. Gary is here. Zlata is here from Macquarie Street in the CBD. Awesome. Bill and Ben is here, and Bill and Ben is referring to our Cooper case that I am going to talk about. It is coming up, and Bill and Ben says it is suggested Cooper might appeal. Can't confirm it, but visit her Facebook page. Okay, there we go. I think that might have been mentioned in the Domain article as well. So that will be interesting to follow that. Melissa is here. Grant is here, and Grant is looking forward to more great, pragmatic, no fear or favour, honest strata advice. Thank you, Grant. And I've got a long comment here from Richard, which I'm going to come back to. And Sean M is here. Tim, good to see you. Haven't seen you for a little while. Must be snowed under. Busy, busy times. Kelly, Joe, Emiliana. Awesome. One more thing I want to add before I welcome in our special guest is that there is a very interesting case that has come out of Queensland, once again, that I stumbled across this week. I think it may have been Frank Higginson or Chris Irons over at Hines Legal, who are very good at keeping us updated on what's happening when it comes to COVID and Queensland. Rochelle will put the link to this case in the comments. Queensland Tribunal case. Body Corporate Commissioner case, I should say. And I'm slowing down and hesitating because I'm wondering if I should try to pronounce this case. Rochelle, can you pop the name of the case, which is in the line just above on our notes there, into the comments so everybody can see the name? Pontiana Park, sorry, Queenslanders. So this was a case where an application for an interim order was made by a resident who was not happy that their committee had decided to close the garbage area, the area where all the bins were stored. The garbage area was on the common property, and the committee was apparently trying to reduce the risk of COVID-19 transmission. And they decided to close the bin area. So people had to travel further, as I understand it, to take their rubbish out or put it in a different bin. And they were trying to avoid many people touching the bins, moving them all around. And this particular owner said, that doesn't sound right, and applied to the Body Corporate Commissioner to keep the area open. So for an urgent interim order that the Body Corporate must keep the area open and cannot prevent owners from storing or accessing their bins in that area. And the Commissioner made that interim order. So that is, as I understand it, one of our first COVID cases from around the country. Let me know if you know of any other published decisions. But interesting that it is, in my view, confirming perhaps this position that our committees, our councils, our body corporates should not be acting unilaterally, should not be making these knee-jerk decisions in fear, perhaps, and should really need to be ensuring that they are at all times acting reasonably, resolving in meetings to do things that they have the power to do. So that was an issue in this case, whether the committee actually had the power to do this or not, or whether they had to go to a full body corporate meeting. So interesting there, out of Queensland. If you want to check out that case, I have a feeling we will probably see quite a few more over time. Thank you, Rochelle, for putting the name of that location there in the comments. If you want to check out that case, there's a link there as well. Hello to Natalie. Looking forward to this chat today with a rosé in hand. Awesome. David is here. Excellent. Okay, well, let's not keep you waiting too much longer. I'm going to welcome in our very, very special guest. She is, of course, Dr. Nicole Johnston. Now, Dr. Johnston has been a previous podcast guest. If you want to check out way back in episode 47, what you must know before buying into strata, and more recently in episode 172, we talked about exposing Australia's building defects crisis. And of course, in that episode, we talked about the very, very important report that Nicole had co-authored and produced in June last year, an examination of building defects in our multi-owned properties. After producing that report, Dr. Nicole Johnston's name also almost became a household name in our strata sector. So we're very lucky to be chatting with her today. Nicole is an admitted legal practitioner, currently working as a senior lecturer and researcher at Deakin University's Business School. She is a co-leader of Deakin's Home Research Group, an interdisciplinary research network. Nicole researches strata-related topics from a socio-legal perspective. Her work focuses on strata governance, conflicts of interest, purchaser knowledge acquisition, and building defects in residential schemes. She is the chair of the International Research Forum on Multi-Owned Properties, a multidisciplinary research conference held annually. So we are super, super privileged to have Dr. Nicole Johnston with us here today. I am bringing her on right now. Dr. Nicole Johnston.
Hello, and thank you so much for having me, Amanda. I'm delighted to be here at Drinks this afternoon. I've got my drink here in hand.
Excellent.
Rosé, ready to go.
Rosé. Very good. It is lovely to be here with you and to share a drink with you virtually. We do always like to catch up in person, whether we're at a conference or not at a conference, just having a nice weekend away. It's nice to see you. I've missed you.
Yes, I have too. We need a little girly weekend very soon, as we possibly can. Catch up with everything.
Yes, indeed. But you're here now, and I know there are many, many people watching today and in the comments here letting us know that they are looking forward to seeing you, and I'm sure they are. I'm just a bit distracted because I just saw Kelly's comment about tapping or thumping. I hope it's not my mic that is jumping around here, guys. I do have a stand-up desk, if you've noticed that, and sometimes it gets a bit wobbly, and if my mic is not attached properly, we can get a little bit bumpy. So apologies for that. I will stop touching things. But Dr. Nicole, we are going to talk about building defects, we are going to talk about where you think we're at. We have in New South Wales had a parliamentary inquiry. We've had a number of recommendations made. But before we get there, I'm wondering if those watching are interested in how you came across this topic, how you became interested in it. It may not have been the first place that you started as an academic or as a researcher. Where does your interest in building defects in strata come from?
Yes, well, that's a really good question, Amanda. And when I first started going to strata conferences some 12, 13 years ago, when I started doing sort of more academic work, we were talking about building defects back then. We've been talking about building defects ever since, and it was probably something that wasn't directly on my radar as far as a researcher is concerned, because I thought, I don't have construction knowledge, but I am a chair of a very large body corporate in Queensland, and so I have seen it all, and I've seen some of the issues around combustible cladding. I have had to deal with issues in relation to those revolting pipes that have been implemented that, are basically that sort of PVC that are breaking open left, right and centre and, requiring an enormous amount of work to fix. I've had to deal with developers, I've had to deal with builders, and over schemes, and also, and I think more importantly, the impacts that these issues have on residents, including owners and tenants. There just was no real research direction in that area, and so it became sort of time, I think, that we started to invest in it. And so I started doing some preliminary research to see, well, what was out there in the world, what had people been talking about in relation to building defects. And I was simply amazed that really not many people had really turned their attention to this. It's not only an Australian issue. There are other countries that have been dealing with defects just like we have. And I was surprised at not only the lack of research, but the quality, the low quality of research that had been undertaken. And so we were able to get a very small research grant from, the Picker Group came on board to provide funding, because research happens when you get money to do the research. And so we started going through looking at, what has happened, looking at data, trying to sort of extract that data to make sense of it a little bit better. And so that's where we sort of really started. It was a little bit of my own personal experience dealing with a very complex scheme in Queensland, some of the issues that were raised there, but also just having the conversation over years and years and years about this particular issue and the impacts it was having on people, and realizing there was just a really large gap as far as knowledge is concerned. And that's what we as academics are. We're knowledge seekers. That there was a real lack in that area, and I thought it was time to really start to close that void and be part of a bigger conversation, and also to be able to use research to inform policy, which is really, really important.
And when your report was published in June last year, it really unknown to you, it turned out to be interesting timing. I think it was published either the day of or the day after Opal Tower was evacuated. Mascot Tower, my apologies, Mascot Tower. So it was big news, and your research, your findings got a lot of attention. We seem to be getting some momentum, at least in New South Wales, with the appointment of our Building Commissioner, David Chandler, and the commencement of a parliamentary inquiry in New South Wales. Now, the final report of our parliamentary inquiry was published in April, and there have been recommendations made. I'm going to assume, Nicole, but let me know if I'm wrong, that you're across those recommendations, because I did want to ask you what you thought of them. Are we moving fast enough on this issue when it was identified in your research, and also identified in the parliamentary inquiry, how urgent the need to properly regulate building standards, building quality is in New South Wales? That's where the report was directed. Especially now, in the time of COVID, we have governments at all levels saying that building and construction needs to go full steam ahead. That makes you feel a little bit nervous.
Yes.
Where do you think we're at, and how has COVID impacted, do you think, the progress of this issue?
Yeah, so I think, New South Wales has certainly turned its mind to this issue, I think, the most in a way. I think probably the fact that there wasn't a commissioner and there wasn't really a dedicated regulator. I think, the fact that David Chandler has been appointed now, I think it's a year since his appointment, and he's certainly going, and doing a lot of work. The problem is, and what COVID has really shown is, when you have any type of crisis, and COVID is the biggest one that we've faced in our lifetime, obviously, is the attention gets turned away from our normal regulatory processes, so our legislation going through Parliament, and obviously we need to have other things, attention towards how to deal with the COVID crisis, and that's really what's happened. So a lot of legislation, and you see this with the bill that's been sitting there for a while in New South Wales, that really will give David Chandler as the Commissioner certain powers to go forward with his work, has really sort of stopped in a way, and hopefully it'll get back onto the agenda very quickly and passed. But the COVID situation has really detracted from movement of legislation, and you see that in relation to just our strata laws generally. In places like Victoria, the bill's been sitting there waiting to be debated in the upper house for some time now. Queensland, I mean, yes, they've got the COVID emergency bill through, but their legislation and their bills have been sitting there for a very long time, not moving forward. And so that's what this crisis has highlighted, really, is that whole process slows down, and then everything gets put on the back burner. And so hopefully in the next sort of weeks and months, that tension will come back towards getting that legislation passed. But on another note, there has been a lot of work and attention still being paid to this crisis. And so over the period that we've been in isolation, I've had lots of people contacting me, think tanks, different government agencies, people doing a little bit of background work in this area. So people have still continued with the discussion with it, even though the legislation that needs to be passed to be able to implement some of these initiatives, especially in New South Wales, has sort of been halted a little bit. I've been speaking to the Building Commissioner's office in New South Wales for many, many months, and they are certainly moving forward, addressing these issues, and they are certainly at the forefront, I believe, in making these substantial change. Now, I think we all have to be very careful to ensure that we're not making change for change's sake. This is a really complex area that's been let go for years and years, and I think pushing things too fast can end up with just slapping band-aids on this problem and actually not solving the crisis that we have. So we have to have a balance here. There has to be time to consider what has gone wrong. We need to evaluate what has gone wrong for the last 20 years and make sure what we are implementing as far as initiatives are concerned are going to be the best moving forward. And so a balance has to be struck in relation to that. In relation to the Senate report in New South Wales, overall, I think it does capture quite well the issues. Does it go far enough? No, I don't think so. I think there's been an over concentration on ACP, or combustible cladding, as there has been across all the jurisdictions. And that's not to say it's not an issue that people are having to deal with, and a very costly issue and a scary issue. The fact is that other building defects are just as, if not more, problematic in buildings, and have big impacts on buildings and the residents. And so we have to make sure that the attention's paid to all the issues, problematic products, and also other building defects that are sitting behind this crisis. And so I think the report is good. I think it's interesting, and I think some of the recommendations are pleasing. I don't think they're really surprising. And but in a way, I just think it doesn't go far enough. I think there's just too much of a concentration on ACP. I think it needs to be, and whether they wanted to do a report just on ACP and then look at the other building defects, and I hope they might continue with their work. There's also a lot of empirical evidence that they haven't included in the report, and so I think one of the issues with the types of initiatives and strategies being implemented is I'm concerned that feasibility studies aren't being undertaken to substantiate these sorts of initiatives, and that research is lacking, and research is really important so we understand the nature of these defects so that we can put proper policies in place and initiatives in place to fix it long term. So I think, there's some interesting things that came out of there. I think definitely, the recommendations around the Commissioner's powers. Obviously, he needs the power to be able to implement these initiatives. So that is critical. And I know a number of the recommendations are dedicated to the Commissioner and his powers. There's obviously a large area there in relation to private certification. Lots of people have spoken about private certification, but I think it's really important that everyone goes back to the Act to see what the functions and powers of private certifiers are, and see whether that has to change. So there needs to be reform in relation to the functions and powers that they actually have. And also we need to think about the conflict of interest issues, because each of the states, as far as I am, and I'm sure someone will correct me if I'm wrong, there are conflict of interest provisions in the legislation in relation to private certifiers or building surveyors in the other states. The problem is with conflicts of interest, and I've written a lot about conflicts of interest in other contexts, is they're extremely difficult to manage and monitor. And so you either have to have clear prohibitions when they're complex conflicts of interest, like some of these are, but managing them through a disclosure mechanism the result that people want never is the outcome. And so I think we have to look at those provisions differently and either have clear prohibitions, because disclosure and some of the wording in the conflict of interest provisions are problematic, I think. So I think that's been flagged, but I think they're sort of saying the same argument, and I think people need to look into that a little bit further. The only other comment...
Sorry. I'm just going to jump in and say what I am hearing, Nicole, is that this needs an holistic approach, and interesting that you take the view that we shouldn't necessarily be moving quickly or too quickly, and there's not necessarily anything wrong, and perhaps the situation calls for some consideration and making sure that we get it right, rather than once again getting it wrong and having perhaps to undo it. Because there's a lot there in what you've said in terms of what you think needs to be addressed. I keep looking over to the screen because I'm looking at the recommendations myself, and things that jumped out to me were the proposal or the recommendation to appoint a strata commissioner to sit within the building commission. I think that was an election promise by the unsuccessful party in New South Wales last election, and that the New South Wales government explore additional financial assistance measures for strata homeowners who have major defects and cannot claim under statutory warranty. So interesting calls there for action, which I think a lot of owners, committee members who are dealing with this on the ground would support.
Oh, I think, this is the issue around support, is that people need to have a conversation with someone that is not going to cost them a whole heap of money to get their basic rights and have a basic understanding about what they're dealing with. And I think, we've had a body corporate commissioner in Queensland for a really long time. Their remit seems to be different, although from reading the recommendation, it sort of seems to be that the strata commissioner, if this comes to any sort of eventuation and actually gets implemented, they are to determine their own remit, which I think's slightly odd. But anyway, we've had a building commissioner in Queensland, but their powers are limited and their role is very different from what I think has been, what the thoughts here in relation to a strata commission. I think it's always difficult when you appoint someone and people are looking for legal advice, and we've got a really great legal fraternity, a strata fraternity in this country, that although it's costly for people, it's the way to go to actually get that sort of advice. What would happen in a strata commission is people will be ringing for legal advice and not being able to get that sort of advice. So it becomes a information type of forum, and we've seen how problematic that can be. We see, always have these debates in Queensland about the Commissioner's Office. I heard that, there's issues in New South Wales with the Department of Fair Trading in relation to this, getting different type of advice or information. So it really will depend on it specifically what their remit is and what their powers are to be able to do something in that space. If they can get that right, I think it would be really effective and very helpful for owners dealing with these sorts of issues. So that's sort of what I probably think about the Strata Commission in relation to the funding issue. So they seem to be trying to model it off the Victorian situation, and I actually live in Victoria. The university's in Victoria, so I know a lot about what's happening there. I think, again, there has to be care around putting a figure or a number on this, and this is what happened in Victoria. They said $600 million. This is going to help. The problem is, and this is where we need to look more carefully and think more carefully about this issue, when you start pulling off ACP, or the combustible cladding materials, off buildings, it is going to be exposing other defects that then the owner's corporation will have to deal with. And so you have to be careful about, well, who is going to pay for those underlying defects that you didn't know maybe were there, and whether any type of government funding is going to aid in fixing those defects as well. Because once those sorts of things are disclosed, you're going to have an obligation to fix them, and you may not have the money because you've been dealing with probably a combustible cladding issue for a long time. You may not have an issue to deal with some of those other issues that may be fire related. So I think it has to be very clear how this sort of system works. It's fine to say, this is what happens, and absolutely, that money has to come to fix these buildings. But you have to be very clear about when these other sorts of defects are going to be exposed, who is going to pay for those.
Yes, a lot to think about on the horizon. And on that note, Nicole, what is on your agenda for the future? We have, just in terms of universities generally, we have all been reading, quite sadly, in our media that things are upside down and inside out for universities. I'm not sure what you're experiencing directly, but we hope it doesn't affect all the good work that you have done, are doing, and plan to do for the future.
Yeah, thank you. Yeah, the tertiary education sector is going to, or has been hit, and will continue to be hit very, very heavily for a number of years to come. And so the university sector, we can't apply on, and they can't apply for JobKeeper or are exempt for it. So there's no sort of ability for people to go there. But it's very, very clear that there are going to be thousands of redundancies across the university sector. People have sort of tossed around the sort of 20 to 21,000 jobs in the tertiary education sector in Australia will go. I know for my university, which is a very good functioning university, it's been, it's not as reliant on international students as a lot of the other universities have been, and this is where the core of the issue comes from. So we have been told that 300 jobs will be made redundant, and that process is starting, and we'll start it'll be very clear over the next sort of week or two where we all lie at the end of the day. So it is scary times, but it's scary times for a lot of people in a lot of sectors. But the university sector, it will take a very, very, very long time to recover. And so, we're looking at some real issues for, I'd say, the next 5 years or so to come. And there is going to be some universities that are going to be hit much harder than my university. And so, lots of job losses there.
Well, taking the positive view and planning for the future, as I'm sure you are, I know you are, what is on the agenda for you? You've done so much good work for our sector the last 12 months, really specifically when it comes to building defects, including instituting your forums. You ran a number of forums, face-to-face get-togethers in various states of Australia, and that may be where a lot of people watching this today would have seen you, met you for the first time. I spoke about how wonderful they were on social media and encouraged many managers to attend. Where are they at? Are we going virtual maybe?
We are going virtual. So yes, I'm staying very positive. I want to continue my work, and I must say, my faculty has been very supportive of the work, and they understand the needs of the industry and what we need to do in, both from an education perspective and also a research perspective. And so, I have nothing bad to say about, that they're very encouraging. And so I hope I can continue this work, and I'm pushing every day to ensure that we can get funding to be able to do this work. And so there's a few things, obviously, to continue with the building defects work is really important, because I think we're still not there yet at really understanding it. I've had lots of people contact me about different issues that are affecting their building, which is fantastic. I love to hear from people and what's going on. And so we need to do more work in this area to be able to identify, especially the more complex defects, but also to start to look at, and one of the things I'm really interested in looking at, creating a risk profile. So looking at these defects to see, what the actual impacts are on not only the building, but also people, financial risks, impacts in relation to, life and livelihood and those sorts of things. So I'm really, concentrating my efforts to do more work in that area. I've also done some work recently, which I hope to continue, to start to look at our strata legislation across the states and look at our reform processes. So I've got concerns about that process and the outcomes of that process, and really whether the voices of those that are actually impacted are heard well. And my conclusion is, and I've just finished a book chapter this week, saying that I don't think they are. I don't think the true voices. I think there's a lot of commercial interests that continue to be heard very loudly. Not to say that that's not important, but I think we need a much more holistic approach when it comes to law reform. And also, I'm hoping to do a little bit of work around the impact of COVID on apartment residents. And so,
how exciting.
yeah, because it's obviously, a different way to live. And so when you are contained in an apartment as opposed to a house, it's a different set of circumstances. When you've got children there, when you're working there, when it's a smaller area, when you may not have access to green space, all those sorts of things are much more challenging in this environment, let alone what managers have had to go through dealing with, virtual systems and so forth. And I, appreciate that there's been a lot of work going on. I hear from managers all the time about the challenges that they've gone through over the last few months. So I'm hoping to do a little bit of work in that space. So hopefully we'll hear something good about that. But yes, very exciting is about Strata Concepts. So Strata Concepts is going virtual. So yes, as a few of you will know, we held it in Victoria, in Melbourne and Sydney last year, and it was so successful. It was so encouraging to hear the sort of need for good quality education, and have research that underpins the education that we're delivering to the strata sector and others. And so Strata Concepts was really about providing a really important and good quality education forum to anyone that's impacted or works around, either directly or indirectly, with the strata industry. And so we might be looking at things like educating conveyancers, valuers, all those people that sort of sit more on the periphery that are in really urgent need to know more about strata. We want to bring those in to provide education. But really this is around research underpinning new knowledge, and therefore educating the sector. And obviously strata managers and resident managers play such an important role in that, and also to ensure that they have the tools to take away back into their business and implement. And so I, like everyone probably on this podcast this afternoon on our drink session, has gone to numerous education type of seminars that are either irrelevant, boring, not substantiated as far as the claims that are being made. And then you just walk away and sort of you've got scribbled notes. The whole point of our series in Strata Concepts is that you can have something to take back into your office, into your business space, and implement it straight there. Yeah. So Amanda's holding up our New South Wales building defects rectification toolkit.
Yeah,
so
it's good stuff.
you get that when we start the virtual, we'll it comes with your package. So you get lots of great videos from different types of experts explaining the intricacies of those issues, these building defects issues, so that when you're having a conversation with your clients, you're across the issues. And when you're having conversations with lawyers, construction lawyers, strata lawyers, experts that come in, you're understanding what these issues are, and it's a really complex area. And so we want to make sure that this information is delivered in a really professional education setting, with the tools that people can go back. And as I said, in the toolkit, we've got checklists, we've got letters, we've got motions that you can adapt, templates that you can adapt in your business. And that's what Strata Concepts is all about. And so hopefully around August, September, we'll kick off our virtual tour, but we're also going to have Queensland, Western Australia, South Australia involved. So all the 5 states, we're packaging it all up. And so that's really exciting, I think.
Very exciting.
Yeah.
And make sure you keep us up to date on that. Let us know the dates and how people can get involved, and we'll be sure to share it with everyone. There is just so much to be across, and the easier we can make that information to understand, the more accessible, the better for everybody. I know you and I are definitely on the same page there.
Yep.
Now, I'm going to shift gears a bit because I am mindful of the time, and I know that I have made big promises today, and one of those big promises was that I am going to fill you in on what has happened this week in New South Wales when it comes to the keeping of pets in our strata schemes. Now, I want to keep our special guest here, Dr. Johnston, on because I would really love to get her views on this, being, as she said, across what's happening not just in New South Wales, but in Queensland and in Victoria as well, because we have some differing positions, interestingly, in our various jurisdictions when it comes to pets. But what has happened this week in New South Wales is that we have had a couple of decisions from our appeal panel, the New South Wales Civil and Administrative Tribunal Appeal Panel. One of those decisions I'm calling the Cooper case, and we do have a link to the case which Rochelle will pop into the notes there for us. And the other I'm calling the Roden case, and we'll put the link to that as well. And if Rochelle, if you could pop those names in there as well, so our viewers know which is which. I am going to, as I said at the top of this video, in case you weren't here, I am going to be chatting to David Edwards of DEA Lawyers, who ran the appeal for the Owners Corporation in the Cooper case, successfully ran that appeal. I'm going to be chatting with him on the podcast. We're having a chat next week, and I hope to bring that to the podcast the week after. So we'll get into more detail about the facts of each of those cases and the legal principles. But what I want to do today is give you a summary. And I have already had a full inbox, some comments on the Facebook page, an emotional issue, of course, being about our pets. We have some pro pets, some pet lovers, and some others who may not be so pro pets in our strata schemes. I always try to put my hand up and say, yes, pro pets. I do live in strata and I do have a dog. We last year in my building amended our bylaw, which was a complete pet ban. We amended that to allow pets on application, and that's how I got my Louis dog. So I will take off my pro pets hat and try and put my lawyer's hat on here and give you the summary of the legal principles we now have. Now, out of these cases, they have established this: the fact that a bylaw prohibits the keeping of animals does not by itself mean that the bylaw is harsh, unconscionable, or oppressive. Now, that is different to what we heard our single-member tribunal decisions saying last year and the year before in the Yardie case, that a blanket ban of itself is harsh, unconscionable, or oppressive. Our appeal panel has said it is not necessarily the case that if you have a blanket ban on pets that it's going to be harsh. I'm going to use the word harsh because it's a mouthful saying the other words. So when I say harsh, I'm saying harsh, unconscionable, or oppressive. The other principle that has come out of the appeal panel is that if a blanket ban on pets is challenged by an owner, there is no obligation on an owners corporation to prove that it has reviewed the bylaw or that it can objectively justify the bylaw. Okay, so this came out in the Cooper case at first instance. The tribunal member said it is a blanket ban on pets is not necessarily harsh, but an owners corporation should be able to objectively justify their ban if it is challenged. Now, the tribunal appeal panel has said no, there is no obligation for an owners corporation to objectively justify, because that is to reverse the onus of proof. If somebody brings an application to the tribunal and wants a bylaw invalidated, then it's up to them to prove that it is harsh. It is not for the owners corporation to justify itself. And really helpfully, these cases have given us a framework for determining in New South Wales under Section 139 whether a bylaw is harsh. What is it that makes a bylaw harsh? How do we work this out? And the Tribunal Appeal Panel has said you have to look at the terms of the bylaw. Okay, pretty obvious. You have to read the bylaw. You have to know the history of the bylaw. How did the bylaw come about? When was it made? Was it made on registration of the plan? Was it made afterwards? Why was it made? You have to look at also the circumstances in which the bylaw came to operate on various owners. So when did these owners buy in? Was the bylaw, was the ban on pets in place at the time they bought in? Did they buy in with knowledge of that? Or is it something that was changed when they came in? So that's going to be relevant. And any other particular circumstances that might otherwise demonstrate that the bylaw is harsh. So the particular circumstances of the owner who is complaining about the bylaw, that's going to be relevant. What is not going to be relevant, our Tribunal Appeal Panel has said, is general contemporary community standards. Not relevant. Now, this was in the Yardi case in 2018. The tribunal member said contemporary community standards are relevant to working out whether these kind of bans are harsh. Appeal panel has said no. In the context of a strata scheme, the relevant community is the lot owners inside that scheme. Looking out to what's happening out in the world and with the general public is not relevant, and it is not something that the tribunal should look to or take into account. Now, in the Cooper case, the Tribunal Appeal Panel found that the evidence did not demonstrate that the bylaw by its terms, having regard to the circumstances in which it came to operate, and having regard to the circumstances of the particular lot owners, it could not be considered a harsh, unconscionable or oppressive bylaw. So very much the circumstances of the applicant who's challenging the bylaw are indeed relevant. The Tribunal Appeal Panel said there's no fundamental right to keep a pet within your strata lot. That was definitely argued, that we have an incident of our basic right of habitation is that we can keep a pet. Tribunal Appeal Panel said, no, you live in a strata scheme, and that right is constrained, it is fettered by the provisions of our strata legislation. So it is not necessarily the case that a bylaw has a blanket prohibition or operates to affect everybody in the same way, not necessarily the case that it is harsh. It could be the case that a bylaw that removes an existing right from an owner, a right that an owner used to have yesterday, because of the meeting that happened the next day, they no longer have, it could be the case that that could be a harsh bylaw. But very much at the front of the appeal panel's mind was that owners acquire their interest in property knowing what the bylaws are. Now, I am going to just flick over to our comments here. I am expecting that we will have, and I would love to hear your views on this case and on the decision that's come out of our appeal panel, what you think as managers dealing with buildings that may have pet bans, dealing with owners who have concerns about these cases that have come out. I definitely have a number of owners in my inbox who are querying the effect of this case, querying the accuracy, if you like, the legitimacy of this decision. We've already had a post here today that some people have seen that Jo Cooper in the Cooper case has said she's going to appeal, that she said that publicly. That will be very interesting to watch. And I have a note here to raise this. I have been contacted by a few media outlets wanting to discuss the impact of this decision, these decisions from a legal perspective. And I did want to say that if there are any residents of New South Wales, apartment buildings, wherever you are in New South Wales, and you are impacted by these decisions, either you have a pet and there's a ban in place, or you want to have a pet and there's a ban in place, then please get in touch with me, because these journalists who are contacting me want to talk to you. They want to understand how these decisions are impacting people who are living in apartment buildings. So if you want to bring your story forward to let these outlets know how this is impacting you, I'm giving the legal commentary, and to have that story of how you're impacted in your homes would be very interesting to these journalists. So get in touch with me, put a direct message on the Facebook page, or send me an email, amanda@yourstrataproperty.com.au. Managers as well, if you have residents who you know who are asking questions about this, feel free to send them my way. Alrighty, so Dr. Johnston, putting you on the spot a little bit here, I know. What are your thoughts on this, having heard all that?
Well, I'm very much against blanket bans in relation to pets. I don't, and especially, I suppose coming from Queensland in particular, where we've been dealing with this sort of issue, like other states, I suppose, for quite a long time. I think blanket bans are out here as from the last information. I mean, it's not my area of expertise looking at these specific bylaws, but, it's just ridiculous. I think you can deal with the nuisance elements that come about when people have problematic pets differently. You can regulate, I think, but to have these blanket bans, I think, in this day and age is actually outrageous. I hope it gets appealed and I hope it gets overturned.
Yeah, it's a difficult one.
It's unreasonable. I think it's unreasonable. But, Queensland has a different sort of issue
yes.
around reasonableness than New South Wales, clearly. So,
Yes, there is definitely case law in Queensland to the effect that bans on pets, I think bans on pets full stop in Queensland are unreasonable, and you can't have unreasonable bylaws, I think is the case, or bylaws that prohibit, that it may even go that far. I'm not sure what the position is in Victoria about pets.
Yes, I know I should know, but I
No,
have to have a
not
look.
at all. Not at all. We can find out. But in I think it was in the Roden decision. So they're two separate decisions, and Roden also decides a case of Spears, which was about a limit. A limit. Can we limit to one small dog, for example? And the tribunal said yes, you can. There's nothing harsh about placing a number limit when it comes to the bylaw. Yes, it was brought up the example of if you're in a freestanding property, you're not in strata, then you have the option to regulate as you like. You can say animals can come in here. You can also say, no, animals are not allowed to come into this property. When you're in a strata property, you are sharing that common space with others who also call it their home. So the way that our legislation is set up is that it is essentially a democratic process. Majority rules, the majority decide how their home, including their common spaces, are going to be used by others. So, all right, I am going to venture over into these comments here that are coming through, and we'll share some of these opinions. I'm not sure how far we go. Gary saying, one great nation divided by 6 states and a bunch of territories. That might be a comment on how you're conquering the nation there, Nicole, with your strata concepts. Hi, Jane Ann, who has come in late. Good to see you. We have a case reference there from Bill and Ben. If the Parliament could not authorise the option to blanket prohibit pets, then it must be verging on unreasonable for an owners corporation to do so. Interesting. Sean saying, I consider all bylaws valid until challenged. Yes. Yeah, I suppose so. That is one way to look at it, Sean. Sorry, my legal brain is just whirling away there. I'm trying to think of a section of the legislation that may answer that one. Sorry, I'm skipping through a little bit too fast. Tim, I wonder how long it will be before there is yet another change. The tribunal is an unpredictable jurisdiction. It is frustrating, isn't it, Tim? It's frustrating for us as lawyers who, and I'm sure you as managers as well, who have clients come to us saying, can I do this? Can I not? Is this bylaw valid? Is it not? Am I going to be hauled before the tribunal? Am I not? And for buildings that are being managed, I know where they have knowledge of these things going on, they're holding back from starting proceedings, or they're telling their committees, this is really uncertain. We don't know what the law is here. And for it to flick back and forth the same way it has done when we're talking about the award of damages under Section 106 in New South Wales, which is now before the Court of Appeal, it makes it hard, doesn't it, to give guidance and to operate on that day-by-day basis. Moving down to Henry, the issue, in my opinion, is that the bylaws and the general laws do not take into account the type and size of pet. Having a Jack Russell is different to a Kelpie or a Husky. Yep. And the decision that's come out in Spears, I think you'll find, says that it is not harsh if you do have a bylaw that specifies the type, the size, the number, that you can do that. Others may have a different view on that. There's a few comments about Jack Russells in apartment buildings there. And these comments are getting a little too detailed for me to read out in the short time we have. If you know from day one, then that's what you're buying. Yeah, that was the point of the tribunal there, Sean. Okay, and there's a few agreements there in terms of knowing what you are buying. There's a few typos around, guys. You're making it really hard for me. I don't know what you're trying to say. Greyhounds are great pets. They sleep 21 hours a day. Yep, indeed, Gary. Now, we have a few minutes left. And if you have questions, I want you to use this time to pop your questions into the comments section, whether they be about pets, whether they be about building defects, pop them on in. And as we did last week, we had Paul Keating from Strata Community Insurance here as our special guest. And Paul very generously came back and answered some questions after our video ended. And I think even maybe on the weekend. And I did the same. Happy to do that for you and to give you as much guidance as we can in this difficult world that is strata living. Do you, Dr. Johnston, want to add anything that I may have skipped over that you were burning to share with our audience?
No, but I just did see a question earlier about the bond scheme in New South Wales in relation. I just can't remember see where that was, but anyway, I think it'll be interesting to see how that works. I have some concerns about the bond and the scheme and how it's going to work. In reality, I don't think there's enough because it's come in and we're still going through the process to see how that's actually going to work. But I think the problem with building defects, as many of you know, is that defects arise, and different types of defects arise at different times of the life cycle of a building, or in that early period at least of a building. So, the issue is with the bond that a lot might be used up early for a particular type of complex or material defect, and then other problematic defects might arise, and then you're going to be in a bit of a hole, I think. So it'll be interesting to see how that bond actually is going to work. But I think it's a complex issue with different aspects to it. That's it's a bit of a hard issue to fix with just a couple of different types of initiatives. But we'll wait and see, I think.
Yes. Thank you very much. I think it was Joe who asked that question earlier on. There is a comment here from Natalie. We're getting in trouble, Nicole, because I also made a promise that we might talk about gender. The reason I threw that in to my teaser email was that I was having a quick scan through the Senate inquiry report, and I did notice that at one of the paragraphs there you were referred to as Dr. Nicholas Johnston.
Dr. Nicholas, yes. So when I was reading through it too, I thought, I didn't see his work. And then I realised it was me. Yes, but this is not the first time. And concerning, obviously, that, it's a pretty straightforward name, I would have thought, Nicole. Nicholas is a longer word, but anyway.
But you're talking about building and construction. You're talking about building and construction. I think there may have been a bit of unconscious bias there. Definitely, look, other female lawyers will say this as well, and perhaps strata managers, that we do get phone calls saying, "Can I speak to Mr. Farmer?" And when I was a little bit younger, it doesn't happen much anymore, at least not in my team. But having a phone call that said, "Oh no, but I want a male lawyer."
Yes.
To which I say, we ain't got any of those.
And I think people are quite surprised in the strata research environment as well, that most of the researchers in strata are female researchers. So if you look around the country that's doing the research, most of us are female researchers, and a lot of us are doing, what have been thought of in the past as male-dominated areas. It's ridiculous, but so I did sort of, and Natalie will probably give me a little bit of a slap on the wrist for not contacting the Senate to get them to make an amendment to the report, and maybe I should. I'm sure Natalie will tell me one way or another what she thinks.
Yes, I'm seeing a comment there from Sean M saying, "Nicole, how does a lowly strata manager get a job in your team? I love policy." And it shines through what you do too, Nicole. You really love this stuff.
I do. I'm very, very passionate about it, and I'm always, but the thing is with, research, I think, and many of the researchers in this country that deal specifically with strata, we are, or at least hopefully we are, really open to having great conversations. And my position has always been with my research is that we're in it together. And so I want to hear about your experiences, your opinions. I want us to sort of co-create research. And so, I'm always open, and, I'm pretty good with getting back with people on LinkedIn when they sort of reach out to me, and we have conversations about what you think is important from a research perspective to assist us with the challenges that we're dealing with in the strata sector, or, and it might be specifically in the strata management sector. And so, I like to be I like every voice to be heard in these sorts of discussions. And so it's really important to reach out to me. I'm very open, and I love to have a chat to anyone. So please do so.
Yep, absolutely. And you can find Dr. Nicole on LinkedIn for sure. And she will be letting us know when she's running her Strata Concepts online so that we can all join in. And I do want to put a final reminder out there for you to get in touch with me if you are a pet owner in Strata or you're dealing with a pet ban. I do have a series of journalists who have contacted me and are looking to talk to you with the support of my legal interpretation of these cases as well. So do get in touch if you're a manager and you know these people, or you're a resident. You can drop me a Facebook message or an email. All right, I'm seeing some we need to talk there. I don't know, Natalie, if that's to Dr. Nicole, or if that's about pets. But thank you so much, Dr. Nicole Johnston, for being my special guest today. We never do get through much. I think I've had about 3 sips.
I know.
Too much talking to do, so we need to get together in person and off air, perhaps. Sorry, guys.
But absolutely, because I'm here on the beautiful Gold Coast. So I moved up here from Melbourne because my parents are in Queensland. I wanted to make sure they were doing the right things in isolation. And so I set up. And so today's been a nice balmy, about 25 degrees, I think. So I'm in a little summer dress and happy as.
Yeah, look at you. It's been pouring rain all day here in Sydney, and that's why I can't get my light right, and I'm dark, but I'm still here, guys. Excellent. Thank you so much for your time. Thank you, everybody. As I always say, if you've enjoyed this, give us a thumbs up, a smiley face. We send it out to so many. It gets watched by hundreds, sometimes thousands of people afterwards on Facebook. You guys really make this event something enjoyable for us and always for my guest as well, and keeps me coming back. It's a little routine now on a Friday, settling in for happy hour. And I am hopeful that you're all enjoying it too, even as things start to gear up again. Kids back to school this week, and maybe the pub's open. 4 o'clock Friday, we're here. Thank you so much, everybody. See you later.